23 CR 15, State of Ohio versus Jeremiah James Johnson. And are you Jeremiah James Johnson appearing there on the screen that's marked Cardinal?
Yes, Your Honor.
All right. Mr. Johnson's represented by William Armentrout, and the state's represented by Adam King. This is a hearing being conducted by Zoom pursuant to notice, purpose of which is for a plea hearing. Mr. Armentrout, you and your client an agreement that this matter be conducted by Zoom rather than him appearing in person?
Yes, Your Honor.
And you're all right with that, Mr. Johnson?
Yes, Your Honor.
All right. The defendant is charged in an indictment with a co-defendant, Danielle K. Denowitz, with illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, a third-degree felony, and aggravated possession of methamphetamine, also a fifth-degree felony. Now, Mr. Johnson, I have been presented a plea of guilty form that is a three-page, actually four-page form here. And the first page I'll show you on the camera has the caption of the case with your name on it and the case number, and it has plea of guilty, and it shows that you're going to withdraw your not guilty plea and plead guilty to count 1. I'm going to hold that up to the camera and ask if you recognize that form.
Yes, Your Honor.
All right. And on page 3, about a third of the way down the page, there's a sentence that reads, "I enter this plea voluntarily." And for the record, there's actually 2 pages attached, 2 copies of page 3. On the first one I'm looking at, it has a signature of the Mr. King and Mr. Armentrout. And then I'm going to show you the second page, second copy of page 3, which appears to be a signature for defendant, a copy of that fax, I assume. And I'm going to hold that up to camera. And is that your signature there that I'm showing you on the camera?
Yes, Your Honor.
And when did you sign this agreement, Mr. Johnson?
I believe it was on the 1st.
All right. And had you been in touch with your attorney and talked to him about the matter before you got the agreement?
Yes.
And did you understand that when you signed it, it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
And do you feel that you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And it's been about 5 days since you signed it, so is this still what you want to do today?
Yes, Your Honor.
All right. Okay. One of the things I meant to tell you earlier, since you're not sitting in the courtroom next to your attorney, if you have any questions that you need to ask him, or if you would like to speak with him at any time in this proceeding, just tell me, and then I can put the 2 of you into what's called a breakout room on the screen, and you'll be the only ones that'll be able to see or talk to each other. The rest of us will not be able to hear that, okay?
Yes, Your Honor.
All right. Do you need to talk to him at all before we go any further?
Yes, please.
All right.
Thank you.
I'm going to create a breakout room here. There's going to be a button come up that says join breakout room, and you'll click on that and it'll be the 2 of you. When you're done, you'll hit leave the breakout session, and then you'll have to log back in, because at least since they made the upgrades in our system, it doesn't allow you to come directly back. So you'll have to re-log in.
All right.
All right, I'm activating the breakout room now. But when they did the upgrade, you have to re-log in. And again, they say there's a button that's supposed to be at the bottom of the screen, but nobody can ever find it. So,
We're ready to proceed.
all right. Okay. Now, Mr. Johnson, going back to page 1 of the agreement, excuse me, it says that you're going to plead guilty to the charge in count 1, illegal conveyance of drugs of abuse under the grounds of a specified governmental facility under 2921.36A2 of the Ohio Revised Code, a third-degree felony. States you understand the maximum penalty for that could be 36 months in prison. If prison term is a 9-month minimum, there's certain levels in between. There's a fine available of up to $10,000. You understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
Yes, for you, for Riley County.
Well, other than this case here, which is pretrial supervision, have you got any convictions that you're on probation for?
No. Your
Okay.
Honor.
Now, under the law, Mr. Johnson, if you should be sentenced to prison for this offense, if you're convicted, once you complete that sentence imposed by the court, the law provides that the adult parole authority may, at their option, put you under what's called post-release control supervision for a period of up to 2 years. That means you'll be supervised by a parole officer on the terms set by the APA, and if they determine that you have not complied with those conditions, then they can make you go back to prison as a sanction, even though you've served the entire term that was ordered by the court, for an additional period of up to 9 months for any single violation. But there is a cap or limit of half of your prison term for one or more violations. But if you commit a new felony while under post-release control, then in addition, whatever sentence a judge in the new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the new case. Do you understand that?
Yes, Your Honor.
All right, now, under the law, I'm not required to sentence you to prison for this offense if you're convicted. I can impose what is called community control, or what most people know to be probation. That means that you could be put under the supervision of a probation officer from the county probation department for a period of up to 5 years under terms set by the court. Now, if during that period of time the probation department felt that you were not in compliance, they would file a written notice of that with the court, give you a copy, there would be a hearing, and you would be entitled to have an attorney represent you at that hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to 36 months in prison and fine you the $10,000. Do you understand that?
Yes, Your Honor.
All right, now the charge in count 1, Mr. Johnson, alleges that on or about September 4, 2022 in this county, Highland County, Ohio, that Danielle K. Denowitz and you did knowingly convey or attempt to convey onto the grounds of a detention facility, the Greenfield Jail, a drug of abuse as defined in ORC 3719.011, to wit methamphetamine, in violation of section 2921.36A2. So that is the charge, which is a third-degree felony with the penalties I just explained. Now, do you understand what it is the state is accusing you of having done, what they said you did, when, where, and how they alleged that you did it?
Yes, Your Honor.
Have you discussed the nature of that charge, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to get you to plead guilty?
No, Your Honor.
Now, on page 2, there are 3 lines that are printed in bold and underlined, and I'll read those at this time. Defendant shall enter a plea of guilty to count 1. State will dismiss count 2. State and defense jointly recommend community control and substance abuse treatment. Defendant shall agree to cooperate fully in the prosecution of the co-defendant. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, Mr. Johnson, the matter of sentence is up to the judge, not the parties. So even though the state's agreeing with your attorney, the sentence ought to be community control or probation, that's not binding on the judge. And so once the information is presented about the sentencing, if you plead guilty, if I determine that that's not the appropriate sentence, I could go ahead and sentence you to prison for anywhere between 9 and 36 months, according to the increments that are provided by law, as well as fine you $10,000. You understand that?
Yeah, Your Honor.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, Your Honor.
All right, now, you have certain constitutional rights you must understand before I can accept a plea of guilty from you. First, you have right to counsel. Mr. Armentrout was appointed to represent you. Now, his appointment wasn't simply to work the case out, but to provide any defense to you that you would like him to provide that you think might be available to you under the law. So, if you decide you don't want to do this, that you don't want to plead guilty, you'll continue to have legal representation throughout the case, and including a trial, if that's what you want. Do you understand that?
Yeah, Your Honor.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are selected for summons for jury duty on your trial date. 12 of those folks will be selected from that group, and once they're selected, the evidence will be presented and they'd be instructed on the law. And then that jury would then decide by unanimous verdict, meaning all 12 of the jurors would have to agree on whether the state proves your guilt. Now, if you decided you didn't want to try to have a jury trial, but you didn't want to plead guilty, you can waive in writing, that means to give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to be come in voluntarily, at your request, the court will issue a court order. It's called a subpoena, and that subpoena would order those people to come to court to be available to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, Your Honor.
All right, Ben. Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. If you decide not to testify, the fact that you did not testify in the case cannot be used against you at any time by anyone involved in the proceedings, and in fact, no one can even mention it or comment about it during the proceedings, with one exception. If there's a jury trial and you do not testify, the judge then instructs that jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been indicted and accused of this crime. In fact, under the law, you're not required to present any evidence at all in your defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally you entered a plea of not guilty, Mr. Johnson. That plea denied the allegation in the indictment, denied you committed any crime. And that plea exercised or invoked all the rights that I have explained to you this afternoon. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that they're a crime, that you committed that crime. And that plea waives, gives up all the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea is. With that exception, your plea of guilty would waive or give up your right to a jury or a court trial. It would waive or give up your right to confront witnesses against you and to cross-examine through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination because by saying you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state is no longer required to prove that you're guilty. Plea of guilty also waives or gives up any right to file an appeal that you think you could have had up until this point in the case. Now, if I should sentence you the maximum sentence, or under the limited circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
Right now, do you have any questions about the charge or the possible penalties?
No, Your Honor.
Do you understand it?
Yes, Your Honor.
Do you have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, Your Honor.
And you understand again that the recommendation as to sentencing is not binding on the judge?
Yes, Your Honor.
Do you have any questions about the constitutional rights that you have had explained to you?
No, Your Honor.
You understand those?
Yes, Your Honor.
Do you have any? Do you have any questions about the plea of guilty? What it means? What will happen if you enter that plea here today?
No, Your Honor.
You understand that?
Yes, Your Honor.
Okay. Is there anything you would like to speak with Mr. Armentrout about before we go any further? If you need to talk to him again, that's fine.
No, Your Honor.
You have any questions about anything that I've explained?
No, Your Honor.
Then is it your decision to withdraw your not guilty plea and plead guilty to this charge?
Yes, Your Honor.
And you're doing it voluntarily?
Yes, Your Honor.
And I'm not sure if I asked you this already, but I'm going to make sure you are a U.S. citizen.
Yes, Your Honor.
All right. Then as to the charge in count 1 of the indictment that alleges that on or about September 4, 2022 in Highland County, Ohio, Danielle K. Denowitz and Jeremiah James Johnson did knowingly convey or attempt to convey onto the grounds of a detention facility, Greenfield Jail, a drug of abuse as defined in ORC section 3719.011, to wit methamphetamine, in violation of section 2921.36A2 of the Ohio Revised Code, the charge of illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, in violation of section 2921.36A2, a third-degree felony, carrying a possible prison term between 9 and 36 months in increments provided by law, and a fine of $10,000. How do you plead?
Guilty.
All right, the court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of the same, pursuant to Criminal Rule 11. Plea is accepted and ordered filed. Defendant is found guilty of the charge in count 1, as set forth therein. Count 2 is dismissed. Court will order a pre-sentence investigation be done by the probation department, which will include an assessment for substance use disorder and or mental health issues that might require treatment. Sentencing hearing will be May the 3rd at 9 a.m. That'll be in person here at the courthouse. Bond is continued. Now, my understanding you're now at Cardinal Treatment.
Yes, Your Honor.
Where is that located?
It's right beside TCC.
The address is 4300 Old Side Trail. That's in Portsmouth, Ohio. The zip code is 45662.
Now, is this part of TCC or is that separate?
It's separate.
All right.
For different entities.
When did you come into your facility?
He actually called me yesterday from TCC. He was having some issues over there.
Okay.
He said there was some drug use going on over there. He wanted to get away from. So I went and picked him up and brought him straight here.
All right.
From TCC.
Okay. Well, Mr. Johnson, the order that I issued originally said that you were to remain at the counseling center until further order of the court. And so in the future, if you think you have the similar problem, because I've seen a little pattern here, you know, you went to King's Daughter and then you left there, and then probation arranged for you to be in 2 different facilities. You didn't show up. And then I ordered you arrested. Then I put you at TCC and I said stay there until further order of the court. If you leave, because it's not a lockdown facility, you come back to jail. So what you did is you did this on your own. Now, Mr. Arjima, did he check with you ahead of time for this?
No, I found out today he left against staff advice, and then
Okay.
today I got a call from Cardinal.
All right. So in the future, you know, you're not to leave that facility. If you do, then you come back to probation department and they'll take you to the jail or bring you before the court, but you're going to stay there. I'm not going to have you jumping around anymore. And then I'm not asking for you, I'm going to ask you some questions here in a minute, then you can answer, but right now I'm not asking for any comment. This is a lecture, and in a lecture you listen. And so it's the order of the court as bond that you remain at the Cardinal Treatment Facility, and if you decide to leave there, or if you are kicked out, you are to report to the jail. And then probation will come out to the jail, and we'll get your attorney, and we'll decide what's going to happen. That's if that's before sentencing, if that happens before May the 3rd. So you're to be here on May the 3rd. All right, so count dismissed. Bonds continued on condition. Defendant remain at Cardinal Treatment Facility. If leave, must report to jail immediately. Not a couple of days later, immediately. Now, the other thing I wanted to ask you about is that I've been informed by the probation department that you came into some money through the lottery. Is that correct?
Yeah, me and my girlfriend did.
Yeah, how much was that?
It's $50 a day for the rest of my life. But I'm trying to get I'm trying to do the right thing so I can have a life, you know?
Mm-hmm. I heard you ordered a car.
No, I was going to, but they took my phone.
Yeah, so you were going to buy a Lamborghini, I heard?
Yeah.
Yeah, that's something to take care of the rest of your life? Sound like a good idea?
No, not really, sir.
No, it doesn't, does it? No. Well, you're going to be ordered to repay the county for your court cost or pay for your attorney fees, and you'll pay your court costs as well. Have you got any cash on you there at the facility?
No.
All right, well, you're going to be required to make those repayments, so you better start saving that $50 a day. How often are they going to send you a check?
Seriously, they gotta get some paperwork or something.
Have you got any of the money yet?
No.
Where's it going to be sent? You got a bank account, or are they going to send you a check?
I got a cash app card, but
Yeah.
I think they're going to send me a check.
All right, well, when you get that first check, you're going to come up to the clerk of courts, and you're going to deposit $1,500. And if you got any left over, that'll be yours. But if it's not enough, then you'll continue to come up and deposit until you've made those payments. Okay?
All right, got it.
All right.
Now, is that when I graduate here?
No, that's when you get the money.
All right.
I don't know whether you're going to get the money before or after. So,
All right, Your Honor.
you know, and you know, I think that the odds on you graduating right now would be pretty slim based on your history. I hope that you do. I hope that you finally become serious about it. But with your history the last couple months, I don't know that very many people would bet on you finishing. But in any event, you pay $1,500 to the clerk to secure payment of your attorney fees and court cost. And that it may not be all of it. It may be more than that. It may be less. But that is what you'll put in. If it's less, you'll get it back, the difference back. And if it's more, you'll have to pay it.
All right, Your Honor.
All right. Is there anything further from counsel?
No, Your Honor.
All right. Thank you. Are you Mr. Queen? Yes. All right. Case number 22 CR 242, State of Ohio versus Jeremy Levi Queen. Present for the state's Assistant Prosecutor King. Present on behalf of the defendant's Attorney William Armentrout. You are Jeremy Levi Queen.
Yes, Your Honor.
All right, Mr. Queen is charged in a single count indictment with aggravated possession of methamphetamine. He had previously filed a motion for intervention in lieu of conviction. In the hearing, the last hearing, he had not yet been accepted for treatment into a certified treatment program. Now, since that time, I have received confirmation from the probation department and Friel and Associates that he is in treatment at that location. When did you start that treatment, Mr. Queen? First appointment, you recall?
I think like the 7th or something like that.
About when?
Like the 7th of March or something.
Okay.
It might have been before that.
All right, so, okay. Because I see here you were screened on the 7th, the 14th, and the 4th. All those were at Friel?
Yes.
Okay, all right. All right, so he is then in a certified treatment program. And I do note that in the report from the probation department that you had tested positive for marijuana and meth on the 7th of March, marijuana on the 14th and the 4th, not meth. And then there was a screen today at 12:30, Friel and Associates. It said that you were negative in all, and it was an unobserved test, but it is going to be sent off for lab confirmation. So you've not used marijuana then since at least the last 3 weeks then, apparently.
No, since
All right,
before I
good.
was in here.
That's because, again, well, I'll go ahead and just explain this now. You are charged with a felony. And normally if a person pleads guilty to a felony, or if there's a trial and they're found guilty, then the judge sentences that person. That sentence for this particular offense could be prison term of between 6 and 12 months. It could be a fine of $2,500. It could also be a license suspension of 6 months to 5 years, or any combination. Or it could be community control or probation, which means supervision for up to 5 years on terms set by the court by the probation department. Set by the court, and then probation department is the one that supervises you. Now, that means then you have a conviction, a felony conviction. Now, there's a provision in the law, which is what's being proposed here in your motion, that you plead guilty, but instead of being found guilty, that you be permitted to enter into this intervention program, which requires you to comply with your treatment program through Friel Associates and anyone else that they would recommend, because that treatment programs can change. They may be set up right now on one thing and find out that that's not enough and you need to do more intensive supervision, treatment, maybe even inpatient, or it can be scaled down as you go. But whatever the plan is, whatever the recommendations are, you have to comply with that. Then you also are put under supervision of the probation department under terms that are less strict and less comprehensive than if you were convicted. And so what happens in the intervention program is you plead guilty. But because you're in a treatment program and you go into this supervision, the court will file your plea of guilty in the file. But I will not make an adjudication or pronouncement at this time that you're guilty. Instead, I will stay the proceedings, and stay is the legal term for basically stop and freeze it, and then we wait for a report. Now, under the law, I could put you into that program for a maximum of 5 years. I order 2, because I think 2 years is enough time to determine whether a person is going to be successful and complete this program. During that period of time, you have to be compliant with your treatment program, and the law requires that you not use any drugs or alcohol for a period of at least 1 year. And even though alcohol is not the issue here, it's also a way of self-medicating, as is marijuana. And even though the use of marijuana in small amounts is a minor misdemeanor, it's still an issue with treatment, and so we don't permit people to use marijuana, even with medical marijuana cards, because it's just a crutch. And they don't really, it's just a way of avoiding dealing with their issues. And so if you do all those things, and any other conditions like pay your court costs and those type of things, then the court will, when I receive notice from the probation and the prosecutor's office that you've been successful, the court will then dismiss the charge. And so, because even though you've got a guilty plea in your file, until you are found guilty and sentenced by the court, the conviction is not, there's no conviction. It takes all those things to be a conviction, not just a guilty plea, but a conviction, entry, and a sentence from the judge. And so, I will set the matter for sentencing here, or for sealing hearing, which means that I'll seal the record, assuming that you don't get in any trouble between the day that I dismiss the charge and the day we set for that hearing. And then that means that it will be unavailable to all of to the public, will be removed from access by the public, will be removed from all the databases and so forth. The records won't be destroyed because they can be viewed under some circumstances, like by a judge or probation officer or prosecutor, if there's a future offense. So they're sealed, but they're not open for inspection, and that's the only basis at any time they could be viewed. So the advantage to you is this. If you complete your treatment program, and if you comply with the conditions of supervision during that period of 2 years, then the case will be dismissed, and even though you pled guilty, you'll not have a felony conviction. And then in the future, you can answer on any applications or any questions. If you're asked by anybody, do you have a felony conviction, you can say with all honesty, no. And it'll be no record of it that you were ever, even if you pled guilty, you were never convicted. So even though you're going to plead guilty, if you're successful, you'll never be a felon. Now, the downside is this. You don't get to try the program, and then if it doesn't work out, come back and say, well, now I want to go to trial. So that's why we go through this process now, because that's the downside. So if you don't want to admit guilt and you want to fight the charge, then you would have to stand on your plea of not guilty, and we would go to trial. So that's why we have to go through this process. Now, do you understand that?
Yes, Your Honor.
Okay. So the agreement states on page 1 that you're going to plead guilty to the charge under 2925.11 of the Higher Revised Code, a 5th-degree felony, aggravated possession of methamphetamine, that you understand the maximum penalty is between 6 and 12 months in prison, fine of $2,500, license suspension of 6 months to 5 years. It's not a mandatory, so there can be community control. Now, you understand that?
Yes, Your Honor.
And are you facing any felony charges anywhere else?
No, Your Honor.
And are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
All right. Now, in the event that you are put into this program and you're not compliant, in the opinion of the probation department, they have to file a written notice of that with the court and give you a copy. It basically alleges what you failed to do or how you're not compliant. Then there's a hearing. You have an attorney represent you at that hearing. If the outcome of the hearing is that the allegations are true, that you have not complied, then at that time, the court would terminate your intervention lieu program and would find you guilty because you've already pled guilty. And then we would have a sentencing hearing. Now, at that time, you could, as I indicated, you could face a penalty of between 6 and 12 months in prison, a fine of $2,500, and a license suspension of 6 months to 5 years, or any combination. But it could also be put on community control. Now, regular community control can be 5 years, but it's much more comprehensive and it's more strict. But it works the same way as intervention in that you'll be supervised by the probation department, again, for up to 5 years. I usually order 3. And if, again, at any time they feel that you're not complying, they file a written notice of that with the court, give you a copy, there's a hearing, and you have the right to have counsel. And if the outcome of that hearing is that you failed to comply, then at that time, the court could revoke your community control and then sentence you to prison for up to 12 months and fine you $2,500. You understand that?
Yes, Your Honor.
All right. Now, the charge in this case alleges that on or about June 16, 2022, in this county, Ohio, Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Higher Revised Code. So that's the charge. The 5th-degree felony, aggravated possession of methamphetamine. Now, do you understand what it is you've been charged with by the state, what they say you did, when, where, and how they allege you did it?
Yes, Your Honor.
And you understand the possible penalties for that offense?
Yes, Your Honor.
Now, have you discussed the nature of that charge, the evidence in the case, the possible legal issues of the case, the possible defenses you could try to raise at trial, and possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to make you plead guilty?
What was that?
Has anyone threatened you to make you plead guilty?
No, Your Honor.
Or coerced you into pleading guilty?
No.
Now, other than being promised that if you enter a plea of guilty that the state will recommend intervention in lieu of conviction rather than a sentence, has anyone promised you anything?
No.
Now, do you hold any license or certification from any state agency that regulates any occupation or profession?
No.
All right, now, you have certain constitutional rights, you must understand, because I explained earlier, this is your last chance to stand on a not guilty plea and defend against the charge. So, you have right to counsel. Mr. Armentrout was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you would like him to provide. So, if you decide you don't want to do this, you'll still be represented with Mr. Armentrout. He'll defend you, including a trial, if that's what you want. Do you understand that?
Yes, Your Honor.
Now, under the Constitution and the law, you have a right to have a jury trial in this matter, Mr. Queen, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, those 12, the evidence is presented, and then they're instructed on the law by the judge. And then that jury decides by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing your right to have a jury trial. That means to give up. And then you would have what's called a court or bench trial, and that means that the judge would be the one who would hear the evidence instead of a jury. The judge would apply the law, and the judge would decide whether the state proves their guilt. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, Mr. Queen, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else who may be present in the courtroom. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a subpoena, and that's a court order. And that would force those people named in the subpoena to come to court to be available to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And in fact, no one can even comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense. So what that means is the burden isn't on you to try to prove you're not guilty simply because you've been accused of this offense. In fact, under the law, you don't even have to present any evidence at your trial. You may, but you're not required to. But whether you do or not, the burden still will be on the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof known under the law. Do you understand that?
Yes, Your Honor.
Right, now, originally you entered a plea, entered a plea of not guilty, Mr. Queen. That plea denied the allegation in the indictment, denied you committed any crime, and it exercised or revoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that there are crime, that you committed that crime, and that plea waives or gives up all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what you plead. But without exception, a plea of guilty waives gives up the right to a jury or court trial, waives gives up the right to confront witnesses and cross-examine them through your attorney, waives gives up your right to use the power of the court to compel or force witnesses being in court to testify for you, the same as the state. Waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. And waives gives up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. It also waives up any right to file an appeal you think you could have had up to this point in time. Now, at some point in the future, If you're terminated or if you're sentenced to the maximum sentence, you could file an appeal. There's some other times you could. Any time you would file an appeal would have to be filed in 30 days of your sentencing entry being filed. Do you understand all that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
And did you enter into this agreement to plead guilty that I'm looking at voluntarily and sign it?
Did I what?
Did you remember signing this agreement?
Yes.
Okay. And did you do that voluntarily?
Yes.
And are you entering into the agreement today and pleading voluntarily guilty?
Yes.
All right. Now, before we go any further, is there anything you need to speak with Mr. Armentrout about?
No.
You have any questions about anything I've explained?
No, Your Honor.
All right. Then is it your decision to withdraw your not guilty plea and plead guilty to the charge? According to the terms of this agreement, recommends you be granted intervention in lieu of conviction.
Okay. Yeah.
All right, then as to the charge, which alleges that on or about June 16, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, aggravated possession of methamphetamine, a fifth-degree felony, carrying a possible prison term between 6 to 12 months, fine of $2,500, and license suspension of 6 months to 5 years. How do you plead?
Guilty.
Thank you. You be seated. All right, the court finds that on this day in open court, defendant is advised of all his constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal Rule 11. His guilty plea is accepted and ordered filed with the clerk. Court finds that the defendant has filed his motion for intervention in lieu of conviction, that he is in a treatment program through Freedom Associates. He is otherwise eligible for community control sanctions. He's not a repeat or dangerous offender, and is otherwise eligible for the program, and the state is in agreement. And therefore, it is ordered to judge that the defendant's plea of guilty be accepted and filed with the clerk. However, there'll be no adjudication at this time, and the criminal proceedings are hereby stayed, pending a report from the probation department and prosecutor's office regarding the defendant's progress in the program. Defendant will be on community control under the conditions for the intervention program previously approved by the court for a period of 2 years under supervision of the probation department. He'll be required to successfully comply with all of those terms and conditions, which will be given to you, and they'll go over that with you, Mr. Queen, and explain those to you. You're also required to successfully complete your intervention plan, including the requirement you must abstain from using alcohol or drugs for a period of at least 1 year. You're also ordered that you must complete the intervention plan, and it may be longer than you think, it may be more, maybe aftercare. It may be increased, more often, or even residential treatment. Whatever is recommended, that's what you'll have to do. Excuse me. You're also ordered to pay the court costs. One thing I noticed in your PSI, you don't have a high school diploma. Have you ever worked on your GED or adult diploma?
No, I have not.
Well, I'm going to put in here that you obtain either a GED or an adult equivalent. I think it's called an adult equivalency diploma, which is kind of an equivalent to a GED. It doesn't require as much testing, I guess, from what I've been told. I want you to work on that simply because I think that'll help you in being more employable. So I want you to work on that. Now, in the event that you comply with your program and comply with all of the conditions, then upon receipt of notice of that from the probation department and the probation or the prosecutor's office, the court will dismiss the charge against you. You'll not be found guilty, and the court will set the matter for a sealing hearing, at which time, that'll usually be in about 30 days, at which time the court will seal the record unless there's been something that's happened that would render that inappropriate. However, if you fail to comply with the conditions of supervision or with your treatment program and plan, then the probation department will file a written notice of that, alleging that with the clerk. There will be a copy given to you. There will be a hearing. You will have an attorney at that hearing. And if the outcome of that hearing is that you have failed to comply, then at that time the court will find you guilty and then could sentence you to a period of 12 months in prison, fine you $2,500, and suspend your license for a period of 6 months to 5 years. Okay, now, is there anything further from counsel?
No, Your Honor.
All right, that completes the case, Mr. Queen. You're not under pretrial supervision anymore, house arrest or any of that, but you need to report to the probation department immediately. Do you have an appointment tomorrow or something, or?
No, I gotta go see him when I leave here.
All right, so go ahead down and see them, and they'll make sure that you get transferred over to the new program. All right, thank you.
All right, thank you.